There is no factum probandum when you talk about the existence of the state. Why? Mandatory judicial notice. Is there a factum probandum when you talk about the territorial extent of a state? No more. It's mandatory judicial notice. Wala raw factum probandum sa existence of a state, territorial extent of states, its political history, its form of government, and symbols of nationality. Kasi mandatory judicial notice. Evidence is not required. Okay? So, do you have to prove the law of nations? There is no factum probandum there because it's mandatory judicial notice. Do you have to prove the admiralty and maritime courts of the world? No. Do you have to prove the political history of the Philippines? Do you have to prove the Philippine Constitution of 1935, 1973, 1987? No. That's part of our constitution and political history. Do you have to prove the official acts of the Supreme Court under Riano? No. Do you have to prove the acts of Congress, executive, legislative? No. Do you have to prove the laws of nature? Your Honor, I saw how the victim fell from the 14th floor of the building down to the pavement. Sabi ng kabila, objection, Your Honor. There must be evidence that things fall. There is no evidence of the law of gravity. What will the judge say? Ulul, you don't have to prove the laws of nature. Your Honor, 2 weeks ago, before the incident happened, it was 7:30 when I flew in from California via Philippine Airlines. Objection, Your Honor. Move to strike out the testimony. There is no evidence that a thing like 7:30 a.m. exists. The court will say, sustain. Oh, everybody will die. Die with a heart attack because we won't stop laughing. You don't have to prove the existence of Cebu or Region 10, Region 11, Region 12. Why none? They're geographical divisions. Why are there things called mandatory judicial notice? Imagine if we don't take judicial notice that there is a state like United States or California. We're the laughing stock of the world. Uy, ang mga Pilipino, hindi alam na meron tayong ganong bansa. We still have to prove it. No. There is no factum probandum on matters of mandatory judicial notice or those matters which the court may take discretionary judicial notice of. Okay? Once the court takes judicial notice, there is no need for evidence. But there are matters where the court has no option but to take judicial notice. And we call them the matters of mandatory judicial notice. Let's talk about jurisprudence that is not in the code. A municipal trial court is mandated under jurisprudence to take a mandatory judicial notice of the ordinances within its jurisdiction. Okay? The RTC has no such obligation unless the law of the place where it sits mandates all courts to take judicial notice of municipal ordinances. In municipal trial courts, there is a mandatory judicial notice required to take mandatory judicial notice over all ordinances within its jurisdiction. RTC, none. Unless, let me repeat, the law of that place requires all courts to take mandatory judicial notice of all ordinances where it sits. Example, there is a specific provision in the Charter of the City of Manila which says that all courts sitting within the territorial jurisdiction of Manila shall take a mandatory judicial notice of all city ordinances. Another instance where the RTC will have to take mandatory judicial notice of a municipal ordinance is when the case is on appeal from the MTC to the RTC. If the municipal trial court took judicial notice already, then on appeal, the RTC will also recognize that taking of a mandatory judicial notice of a municipal ordinance. Another kind of judicial notice which is not mandatory and that is a discretionary judicial notice. Now, before the court can take judicial notice of matters which are subject to discretionary judicial notice, there are certain characteristics of those matters. Must be of public knowledge, capable of unquestionable demonstration, or those which the court ought to know by reason of its functions. Now, when there is a discretionary judicial notice, the court cannot simply on its own take judicial notice. The court will conduct a hearing and hear the parties before it takes discretionary judicial notice. You know, judicial notice may even still exist even after trial, even during appeal, especially when that is material to the resolution of an issue of the case, even on appeal. But the court may take judicial notice, but if it is discretionary judicial notice, the court will require a hearing and the parties will have to be heard. If it is a discretionary judicial notice. But there is no hearing required if it is a mandatory judicial notice. There is another situation where evidence is not required in case of judicial admissions. Judicial admissions may be expressed, it may be implied. Could you look at section 4 of Rule 129? Your judicial admissions cannot be contradicted. The only way to contradict your judicial admission is for you to say that it was done because of a palpable mistake, or the fact that there was no such admission. Palpable mistake, yung hayagang error lang, yung hayagang mali at nagkamali lang. Halimbawa, sinabi ko, ako'y babae, slip of the tongue sa korte. Sabi ng kabila, he no longer can contradict his judicial admission. For the purpose of this case, he is babae. Holy smoke naman, slip of the tongue talaga. Palpable mistake. Sabi ninyo, anong malay namin? Na, palpable mistake. O sinabi ko, ako ay 10 years old. O palpable mistake. I will not be bound by such admission. Yung sinabing isang mode of contradicting a judicial admission is that it was never made or it was not made. Hindi ibig sabihin yan, it was not made. Kasi pag sinabi mo, you made the admission and then you say, I did not make it, that is a lie. The meaning of that is this. That is not what I meant. In other words, another way from politicians is this. I was taken out of context. That's the meaning of that. Now, we were talking about judicial admission, but I want you to look at one element of judicial admission. It must be an admission in the same case. An admission made in another case, in another judicial proceeding, is only an admission in that proceeding. If you want to bring it to another proceeding, that's extrajudicial. It has to be proven. The concept of judicial admission is the same case, the same proceeding. So let us say, Mr. X and Mr. Y are litigants in a civil case in branch 1. There was an admission there by the defendant. They are also litigants in another civil case in branch 2. If you bring the admission of the defendant in branch 1 to the case in branch 2, that admission is not judicial because the cases are different. It is an extrajudicial admission. If it is extrajudicial, it has to be proven. There is a factum probandum. Factum probandum, in other words, means the fact to be proven. You have an obligation to prove through the evidence. And that evidence is the factum probandum. Okay, let me try this. During an investigation, custodial investigation with the police, I said, sir, I will admit it now. My conscience bothers me. I was the one who fired a bazooka at Mr. X. Where is he now? Dead. Where? He was blown off to thy kingdom come. He was blown to smithereens because I used a bazooka. Limbs na lang ho ang natira. Nasaan? Nasa freezer ko po. Will that extrajudicial confession be enough to exempt the prosecution from a factum probandum? That's extrajudicial, isn't it? That's outside the court. Meron pa bang factum probandum ang prosecution to prove something? Pinakita na yung extrajudicial confession niya, nasa hukuman. Piniramahan pa niya. Kasama pa ang lawyer sa pumirma. Meron pa bang factum probandum ang prosecution? Meron. An extrajudicial confession is not enough for conviction. There is still something to prove. The corpus delicti. Okay, tingnan yung Rule 133, Section 3. Hindi sapat for conviction an extrajudicial confession. Kailangan it must be corroborated by evidence of corpus delicti. Now, we are talking about that extrajudicial confession, under the law on persons arrested, detained, or custodial investigation. I'm referring to Republic Act 7438. An extrajudicial confession must be made in writing, and it must be signed by the accused or the person detained or arrested with the assistance of an independent and competent counsel. But even if that is required, the extrajudicial confession is not sufficient for conviction. It must be corroborated by evidence of corpus delicti because of Section 3 of Rule 133. Are there judicial admissions which will not be admissible against me even if I make a judicial admission? Here, example is the admission of an accused in a pre-trial conference must be in writing. It must be signed by the accused. It must be signed by his counsel. Otherwise, it will not be admissible against him. We look at this situation, okay? I was arrested in a bypass operations. Then I was asked by the police officer to sign a receipt containing the following statements. The following were taken from my possession: 10 sachets, 5 tutors, and 5 syringes. Then I signed. It is now offered in evidence against me to prove that those things you really confiscated from me. Could I object to its admissibility? Yes. On what grounds? Actually, that is in the nature of an extrajudicial confession. An extrajudicial confession under Republic Act 7438 must be done with the assistance of an independent and competent counsel. There was no counsel. Oh, there are many cases of that where the police officer asks you to sign kung anong kumpis ka sa'yo. That's not admissible against you the moment you object. But if you do not object, that will be admissible against you. Because inadmissible evidence can be waived.